My name is Donald Rothwell. I'm Professor of International Law at the ANU College of Law at the Australian National University. And I want to welcome you to this simple event celebrating Carolyn Foster's book, which we'll be speaking about this afternoon. Before we commence, I just wanted to acknowledge that we're coming to you virtually today from the lands of the Ngunnawal people here in Canberra, and pay my respects to their elders, past, present, and emerging. So the format for this afternoon's event is that I'm going to introduce our author and invite Carolyn to speak to her work briefly. And then I'll introduce three discussants who also briefly focus on different aspects of Carolyn's book. And then we'll return to Carolyn for a response, and then we'll have some opportunities for some Q&A and discussion. This has been a fairly tumultuous week for international law. Just in the last 24 hours, we've had a decision handed down by the International Court of Justice in The Hague on provisional measures against Russia arising from Ukraine's application based on the Genocide Convention. We've had continuing armed conflict, of course, in Ukraine, and we've had President Biden make some interesting observations about the status of President Putin as a war criminal, which has been generating a lot of debate and discourse. We're not discussing those types of matters this afternoon, but we are discussing an important international law question in relation to, as Carolyn's book is titled, Global Regulatory Standards in Environmental and Health Disputes, which in fact engages in the decisions of a whole range of international courts and tribunals. Carolyn is a professor at Auckland Law School at the University of Auckland in New Zealand. And thanks to the wonders of Zoom, Carolyn's been able to join us, and we also have other colleagues from New Zealand. So Carolyn, I'll hand it over to you for some introductory comments, and welcome.
Well, thanks, Don. Kia ora, everyone, and thank you all for coming along tonight. I know times are difficult at the moment. Thank you to the ANU Centre for International and Public Law for hosting. Don, thank you for organising and moderating. And Chester, Margaret and Esme, thank you for taking the time. Your engagement's generous and it's valuable and it's much appreciated. This is a book about the part that's being played by international courts and tribunals in the evolution of international law as it continues to reach more closely into domestic regulatory and administrative space, focusing specifically on environmental and health cases. In researching the book, I set out to analyse all the cases on environment and health that had come before the International Court of Justice, that had arisen under the UN Convention on the Law of the Sea, or in interstate arbitrations in other settings, or in WTO trade disputes, or investment treaty tribunals. And what I found most fascinating in the research for the book is the core empirical finding that there are distinct commonalities in the reasoning around the delineation of states' regulatory powers and obligations across the range of different international courts and tribunals studied. And these commonalities take the form of the three potentially global regulatory standards that international courts and tribunals are reading into the law and elaborating in their awards, judgments, and decisions. These standards are first, regulatory coherence in domestic measures, in the sense of a proper correlation between regulatory action and its objectives, for example, a rational relationship. Second, a requirement for states to have due regard to the rights and interests of other states and populations in their domestic regulatory and administrative decision-making. And third, due diligence in the prevention of harm to the legal rights and interests of others. These three standards, though applied using a range of different tests, have been read into the relevant law and/or elaborated by all the courts and tribunals studied, almost like a new layer of law between the domestic and the international. This seems like a systemic development, even a development in the structure of law globally as it's perceived in works like Neil Walker's Intimations of Global Law. The cases studied cover everything from Australia's and, in effect, New Zealand's challenge to Japan's whaling in the Antarctic in the ICJ, Argentina's complaint about the pulp mills on the River Uruguay, also in the ICJ, China's non-compliance with its international environmental obligations in the South China Sea Law of the Sea arbitration, Cases like complaints in the WTO, such as Canada's case against US country of origin labelling requirements for meat, and diverse investment cases, for example, Apotex in the US, where a pharmaceutical company producing tainted tablets challenged US enforcement action. These cases can be extremely political. They can put international courts and tribunals in a difficult position, especially as the substantive law is often less precise than might be ideal. The appointments crisis that has forced the appellate body into disoperation at present can be partly explained in this way. Toma Bruder's book on international governance in the WTO analyses how government's non-progression of international negotiations has put WTO adjudicators in a position where they will, it seems, inevitably be blamed for aspects of how they fulfill their role. However, adjudicators in all the courts and tribunals studied are essentially applying accepted interpretive principles to read the three emerging global regulatory standards into the relevant international law. Specifically, they often rely on principles of effectiveness and context, as analysed in Isabel Van Dam's book on treaty interpretation by the WTO appellate body. Now, whether the regulatory standards that are emerging are the right standards is an open question. Essentially, the problem we come up against, predictably perhaps, is that international courts and tribunals are not the right place, and international adjudication isn't by itself the right process to develop global regulatory standards. For all their major strengths, these adjudicatory processes are not sufficiently representative. Yet, the lived experience in these cases shows us that we do, practically speaking, need these or other serviceable standards and the consistency yet flexibility they can be expected to bring. They represent what Nico Krish might call interface norms. That is, they determine the allocation of authority where overlapping domestic and international legal systems collide with or encounter one another. Regulatory cases are challenging, and presently it's the judicial arm of international law that's being tasked with working out what's meant in practice by often rather generally worded international legal provisions in order to apply the relevant international law and make the rulings needed to address the disputes and cases coming before them. International courts and tribunals are carrying out this task reasonably well, but there needs to be wider discussion around assessing the implications of the patterns emerging from their decision making. And I'll leave it there for now, Don.
Thank you, Caroline. So we're now going to move to our three discussants this afternoon. I'll introduce them in order and then invite the first one to commence with their observations. Our first discussant is Professor Margaret Young from Melbourne Law School in Melbourne. Our second discussant is Professor Chester Brown from Sydney Law School. And our third discussant is Associate Professor Esme Shirlow from the ANU College of Law at the ANU. Each discussant will be raising a number of issues and thoughts and reflections on Caroline's book. And then following that, we'll return to Caroline for some further reflections and responses to the comments that are made. So Margaret, over to you.
Thank you, Don, and hi, everybody. I'm delighted to be here, and I want to thank Sybil for hosting this important event and for inviting me to speak. It's great to have the digital flexibility to be here alongside Professor Caroline Foster on the occasion of the launch of her book. I also acknowledge that I'm zooming in from the land of the Wurundjeri peoples of the Kulin Nations, and I pay my respect to their elders, past, present, and emerging. So a book that dwells on international environmental and health disputes could not be more timely after the last couple of years of pandemic, floods, and heat waves. Professor Caroline Foster poses important questions about international law's claim to legitimate authority when disputes between states or between states and investors arise over domestic regulatory activities. She focuses on the judicial articulation of regulatory standards, including the need for states to pursue regulatory coherence, to give due regard to interested others, and to exercise due diligence in the prevention of harm. I wish to engage in my 10 minutes or so with three aspects of her argument. First, relating to international adjudication. Secondly, to the fragmentation of international law. And thirdly, on the obligation of due regard. So let me turn first to Caroline's choice of study on international adjudication. The book refers to a plethora of cases from international courts and tribunals, including the International Court of Justice, the World Trade Organization panels and appellate body, ad hoc investment panels, the International Tribunal for the Law of the Sea, and other ad hoc tribunals. We see jurisprudential development from a wide range of disputes, including disputes arising from state-sanctioned whaling, the ICJ, disputes over efforts by states to enhance solar cell production, the WTO, disputes arising from efforts by states to regulate tobacco sales through packaging requirements, the Philip Morris Ad Hoc Investment Tribunal, and disputes arising from efforts by states to proclaim marine protected areas without adequate consultations with their neighbours at ITLOS. In these and other cases, Foster identifies a trend towards what she sees as global regulatory standards. Foster is part of a group of international lawyers who show alacrity in moving between different regulatory regimes, people like Joanne Scott, Andrew Lang, Toma Broyd, Joshua Payne, Vernon Rive, and of course those on the panel today. This sense that international law is best understood by delving deep into its moving parts is one of the most important mindsets to counter the tendency of international law to be siloed into professional specializations that don't necessarily talk to one another. Caroline also shows a sensitivity to the role of international adjudication vis-a-vis other areas of lawmaking and implementation. She discusses negotiations and points to efforts to develop standards such as regulatory coherence in new regional trade and investment agreements like the CPTPP. My question for Caroline is whether there is a more systemic aspect of the development of global regulatory standards that ought to be perhaps more front and center in her analysis. Here, I'm talking about the institutional asymmetry in judicial dispute settlement and negotiation in fields of international law, especially as it relates to health and environmental matters. For example, while trade and investment disputes are compulsorily litigated, there is no guaranteed dispute settlement for transboundary environmental harm, meaning that legal recourse for affected states is ad hoc if available at all. Moreover, negotiations on environmental matters, including, for example, the current efforts at the UN to achieve agreement on biodiversity beyond national jurisdiction, are weak in their proposed institutional reforms, and the hoped-for global pact for the environment has been sidelined. There is a clear outcome here. States with environmental interests are not likely to be applicants in a court, but the flow-on effect must surely be to sway the development of global regulatory standards. Ecological blind spots in adjudication were discussed by Oren Perez a couple of decades ago, and since then we have a range of concepts that have developed in the science and in the environmental humanities, but that are yet to find full articulation by courts. How, for example, should regulatory agencies take into account interests such as multi-species justice, rewilding, the Anthropocene? When would a court be asked to develop such standards for agencies? Can we really draw a set of globally applicable and legitimate regulatory standards when the tribunals are heavily slanted towards economic bodies? This brings me to my second point, which is the fragmentation of international law. Caroline engages closely with issues of fragmentation in the second part of the book. She notes that achieving greater integration of public international law in a standards-enriched international law will in large part depend on international and national adjudicators, selection and orientation. She draws on studies that show that the more specialised a judicial regime, the greater likelihood that its judges will identify with the social values thought to be realisable through the regime's implementation. This is an important point, well delivered. To extend it further, I wanted to ask how the domestic encounters with the relevant adjudicatory body could shape the evolution of the law. As Hilary Charlesworth and I have shown in our recent work with many ANZL colleagues on national encounters with the International Court of Justice, which just came out in the Melbourne Journal of International Law, there is clear evidence that the experience of acting as applicant or respondent before an international court has lasting impacts on domestic agencies, as well as civil society groupings and other actors. The example of the domestic whaling case that preceded the ICJ case here in Australia, incidentally decided at first instance by Justice Alsop, who this week presided over the appeal in the climate case of Sharma, was interesting, showing how public servants navigated their role in litigating Japan after an NGO had first taken a claim through the federal court. I could go further here, but it might be that Caroline could reflect on how these international disputes have impacted domestic actors, especially regulatory agencies in health and environmental matters. Finally, let me turn to Caroline's excellent work on the concept of due regard. I agree fully with her that this is a more appropriate tool for international dispute settlement bodies than proportionality analysis. The due regard concept allows for an increasingly sophisticated engagement with interests of other actors on matters of global public goods and extending into the commons. I have just a pragmatic question for Caroline that stems from my own experience in working with this concept when advising states and international organizations. The due regard concept is attractive in its flexibility, and one can incorporate interests of justice and equity, as was seen in the Chagas Marine Protected Area case. Pragmatically, how do states understand and perform this standard? I guess this is a broader question for all of the standards that Caroline considers in this work, especially if it is, as she says, a new layer of law between domestic and international law. Rules that are expressed in treaties are relatively easy to communicate and thus adhere to. Are there reforms needed, perhaps even systematic, to ensure that the main actors, the states, are informed of their obligations before they have to be taken to court over a failure of them? Thank you.
Thank you, Margaret, for those opening remarks, and I'll now turn to Professor Chester Brown.
Thank you very much, Don, and thank you to Caroline and all the organisers at ANU for the invitation to be here with you this evening. Caroline and I used to work together in the PhD students' room in the Squire Law Library at the University of Cambridge, where we shared a desk not quite opposite each other, but around the corner from each other for a few years. So it's not just a great honour, but a personal pleasure to be here to help launch this book this evening. Our central theme of Caroline's book, as you've all heard, is the search for the appropriate standard or standards of review in international law by which state conduct should be assessed. And this particular inquiry has caused a lot of consternation for scholars, practitioners, judges and arbitrators on international courts and tribunals for many years. And the appropriate standard of review is particularly relevant in circumstances where international adjudicatory bodies are essentially providing a form of international judicial review of domestic decision-making. For what the international courts and tribunals are doing here is assessing state conduct and deciding whether that conduct meets the relevant international obligation that the state is required to comply with. And this might be said to be not all that far removed from the role of domestic courts and tribunals, which review government decisions for procedural fairness or Wednesbury unreasonableness, like our full federal court, including indeed Chief Justice Alsop did in the Djokovic saga a month or so ago. And if it can be said that international courts and tribunals are indeed performing a type of judicial review function, then there are various questions for them to answer, which really goes to what the standard is they're supposed to apply. Should they simply carry out an objective assessment of whether the state conduct is in breach of the international obligation, or should they accord some form of deference to the decision makers at the national level? And if some deference should be accorded, in what circumstances should that be done, and how much deference should there be? And in this respect, should it somehow matter whether the measure has been adopted to comply with an international obligation concerning, for instance, human rights or the environment? Should it make a difference whether the subject matter of the measure is particularly technical and has been adopted by an expert group? Should it make a difference whether the decision was one reached through a judicial proceeding where due process has been afforded to the affected party? And is it then sufficient to show that the measure is reasonable, or at least not arbitrary? And if so, how is that done? Is it whether the measure is adopted in pursuit of a rational policy objective? Or does it have to be shown that the measure is reasonably related to that rational policy objective? Or does it have to be shown that the measure is the least intrusive but still effective regulatory option available in relation to that rational policy objective? These are quite difficult questions to which there are no easy answers, and you can readily see that even the very first of these questions, whether the policy behind the measure is rational, is one that international courts and tribunals are not. An early NAFTA tribunal, in Canada, gave at least lip service to these issues in its determination of whether a Canadian ban on the export of toxic chemicals was in breach of Canada's obligations under Chapter 11 of NAFTA. The tribunal famously said that it did not have an open-ended mandate to second-guess government decision-making, and that it had to make its assessment in light of the high measure of deference that international law generally extends to the right of domestic authorities to regulate matters within their own borders. Now, this high measure of deference, as the NAFTA tribunal put it, didn't really help Canada in that case, because the tribunal proceeded to find that Canada was in breach of its obligation under Article 1105 of NAFTA. And for the tribunal, this followed almost automatically from its finding that Canada had breached the national treatment obligation. It followed from that the minimum standard of treatment had also been breached. And so council and parties were really left none the wiser as to how this high measure of deference was to be applied or would play out in one case or another, and whether it would have any impact at all, other than perhaps providing some form of Pyrrhic victory in the recognition that there was a balance to be struck between various competing interests. Esme, who is speaking next may well have further comments to add on the topic of deference, which is a subject she's written about very perceptively. But suffice it to say that the quest for the standard of review in international law has almost become the holy grail of international adjudication. Now, one of the difficulties that Caroline correctly identifies in discussing these standards of review is the relative indeterminacy of states' obligations, particularly in the fields of environmental protection and public health. These are typically obligations of conduct rather than obligations of result, if I'm permitted to resort to that dichotomy, which didn't even make it into the second reading of the ILC articles on state responsibility. And the nature of the obligations makes it even more difficult for international courts and tribunals to assess compliance. Caroline explains that governments have sought to adopt increasingly sophisticated regulatory responses to govern this sort of activity, and which seek a greater calibration of provisions concerning states' regulatory freedom on one hand and their compliance with obligations on the other. And the Comprehensive and Progressive Agreement on Trans-Pacific Partnership is noted as containing the most specific provisions in regard to regulatory practice. This treaty even contains a chapter on regulatory coherence in Chapter 25, and a definition of regulatory coherence. But it's one thing to define what we mean by regulatory coherence, but this still begs the question of how it's to be assessed with respect to particular state measures. And it's onto this difficult terrain that Caroline ventures in her book, and she asks three questions. How effective are the regulatory standards elaborated by international courts and tribunals in preserving or enhancing international law's claim to legitimate authority? How appropriate is it to rely on international adjudicatory processes in the development of regulatory standards in international law? And what are the broader opportunities and challenges and dilemmas that arise in the course of international adjudication, participating in the global transition to standards-enriched international law? These are all very important questions for our age, and we are grateful that Caroline has bravely stepped into the breach. The role of international courts and tribunals is evidently central to these questions. They have had to articulate the relevant standards given the indeterminacy of the applicable treaty provisions. And Caroline has developed a nuanced analysis of the role of international courts and tribunals. On the one hand, they are quite ill-equipped to answer these questions because they are socially and formally constrained by the pleadings of the parties, the parameters of a case before them, and their need to simply find an answer to the dispute. But at the same time, Caroline praises and defends the role of international courts and tribunals, as they've played a very constructive role in the elaboration of these regulatory standards. And they've developed various tests which embody formulae for determining how the balance of legal interest can be struck. Sometimes these are successful, other times not so. If we think of the obligation to afford foreign investors and their investments in the international minimum standard of fair and equitable treatment, if we just leave aside for one moment the question as to whether there are two standards there or one, it can plausibly be argued that a state's compliance with this obligation can be assessed by reference to up to 12 or 13 different considerations, depending on how you count them, all of which have been applied by arbitral tribunals. In this respect, the obligation to provide fair and equitable treatment could be satisfied by conduct which is fair, just, even-handed, non-discriminatory, reasonable, non-arbitrary, non-prejudicial, and proportionate. It might also be satisfied by a state decision-making process which accords with due process and procedural fairness, propriety, and candor and transparency. It could also be satisfied by state conduct which is in good faith, and by state conduct which doesn't defeat the foreign investors' legitimate expectations. But the replacement of one set of indeterminate adjectives of fair and equitable treatment by another set of reasonably amorphous concepts doesn't really take the analysis all that much further forward. And as I outlined earlier, the more contentious question is arguably how to assess whether the state's conduct is in fact fair or just or reasonable, etc., and how the balance is to be struck between the various competing interests. And this brings us back to Caroline's book, in which he's identified the three golden threads that run through the practice of international courts and tribunals. The first of these, as we've heard, is regulatory coherence, by which the international legality of regulatory measures is contingent on the existence of an appropriate relationship between measures and their objectives. Secondly, the new focus on processual requirements, the due regard requirement, taking into account the interests of other states and their populations. And the third is the requirement of due diligence, which applies particularly in the context of transboundary harm. The attraction of these three standards is apparent, and Caroline's book is impressively thorough and persuasive, and we can all hope that this contribution will assist in bringing about greater predictability and legal certainty in international adjudication. I'll close with just three questions or observations for Caroline to respond to. The first is to wonder whether these three golden threads might also have some application in other contexts beyond environment and health disputes. And if we look at the list of cases currently pending before the ICJ, I suppose we have here in mind disputes over sovereignty, land and maritime boundary disputes, and obligations concerning, for instance, the financing of terrorism. Secondly, Caroline has adopted the position, which Margaret has also alluded to, that when assessing whether a state measure satisfies the standard of regulatory coherence, it's not appropriate for tribunals to read into treaty texts a test of proportionality, whether that be proportionality stricto sensu, which only asks whether the measure is proportionate to its objectives, or at least not manifestly disproportionate, or an extended proportionality test which takes into account other factors. And this is because proportionality ultimately lets international law override domestic democratic decision-making processes. And another difficulty can be found in the way it's been applied by investment tribunals to balance the interests of the state adopting the measure on one hand with the interests of the affected investor on the other. And Caroline argues that a better balancing of rights and interests would not be with the rights and interests of the foreign investor, but with that foreign investor's state of nationality of the other state party, for instance, to the bilateral investment treaty. But I just wonder how comfortably that can sit with the theory that investors themselves have direct substantive rights under investment treaties, and that their rights are not derivative of their state of nationality. And here I'm thinking of the award of the NAFTA Tribunal in corn products and Mexico. And of course, there are many other scholars who have written about these issues as well, which I guess are unsettled. And the final point that I wanted to note is the application of these golden threads are all rather reliant on the evidence that is put before international courts and tribunals. And this is, I suppose, the social and formal constraints of international adjudication that Caroline refers to. Because in the context of environment and health disputes, much of the relevant evidence on which the tribunal's decision is going to turn is going to be scientific and technical in nature, and probably led by expert witnesses. And so the ability of international courts and tribunals to adopt and implement these three standards will still depend in large part on them becoming more adept at dealing with complex evidence, on which there is some work to be done, although that is probably a discussion for another day. Thank you very much, and I look forward to our discussion. Thank you.
Thank you, Chester, for those remarks. So I now turn to my colleague, Associate Professor Esme Shirlow.
Great, thanks Don, and good evening everyone. I'm really pleased to have had this chance to engage with Professor Caroline Foster's important book and to be invited to participate in this launch by offering some reflections on the research and arguments it presents. And as Caroline has outlined in her opening remarks, this book brings into focus the global regulatory standards that are being developed by international courts and tribunals determining health and environmental disputes. And it's a fascinating book, not just for what it tells us about how international courts and tribunals have gone about analysing domestic regulatory choices in such disputes, but also for what it tells us about international law, about the nature of state sovereignty, and about international law's connection with domestic regulatory systems. And it's impossible to do justice to such a rich and wide-ranging work in the space of 10 minutes. So in my remarks, I wanted to focus on the global nature of the regulatory standards identified in Caroline's work. And in doing so, I hope to bring out several interconnected themes that emerge from the book, which hold relevance beyond the subset of disputes which the book engages with. So empirically, the book presents three regulatory standards that are said to permeate the analysis of regulatory disputes in different institutional contexts and under differently formulated treaty provisions. And Caroline convincingly argues that international adjudicators are separately converging around common understandings of what in effect constitutes good regulatory practice. And as Caroline notes, the book shows that through proceedings in multiple international dispute settlement bodies, common systemic international legal developments may be taking place across a highly diverse range of regulatory fields. So a key question raised and tackled by the book is why these common understandings might be emerging. Caroline considers and dismisses, as she said, the possibility that they stem solely from similar treaty text or customary obligations. Instead, as she's explained, international adjudicators are operationalising less determinate international legal provisions to gradually elaborate on standards that are inherent within them. And to do so, they use a blend of textual references, logical inference, principle, and their perception of the legal needs of the regime that they're operating in. Methodologically, Caroline works inductively from international decisions rather than using domestic analogies to argue in favour of particular standards. But the process by which regulatory standards are seen to emerge makes it particularly likely that they will reflect certain legal traditions or approaches to regulation, raising the question of whose values such international regulatory standards reflect. Indeed, as Caroline explains in the book, and I quote, "There is much that will seem familiar in the emergence of regulatory standards. Such standards may be known from domestic settings and in many traditions are infused into our thinking at the most formative stages of legal training." This isn't necessarily surprising in itself. As James Crawford has noted, it is natural that our thinking about law is infiltrated, marinated, drenched with the influence of national legal systems. But accepting that so-called global regulatory standards are being developed by reference to such domestic influences can be problematic. In particular, given the lack of diversity amongst international adjudicators in at least some of the regimes analysed in the book, and given Margaret's reflections that these disputes are also being raised in particular ways and in connection with particular goals, including economic goals as compared to others, it might be asked what makes the regulatory standards identified in this work global. Are they global only because they emanate from international courts and tribunals, such that they can, in a minimal sense, be treated as representative of global regimes from an institutional, even if not nationally or sociologically representative perspective? Or do they truly reflect globally shared perspectives on how regulation and administration should be conducted? Might they even further offer a means for creating such global perspectives, leading, as Caroline suggests in the book, to a sense of unity and community of values? Caroline addresses some of these concerns throughout the book, providing in doing so several important reflections on the role of international courts and tribunals in the development of international law. Her analysis, for example, indicates a preference for the development of regulatory standards in advisory opinions, which will typically open space for more diverse perspectives to be offered to an adjudicator than will bilateral disputes, leading perhaps to such standards being imbued with a more representative and global view of what constitutes good regulatory practice. She also emphasises, as she said, that the development of at least some regulatory standards by international courts and tribunals will attain greater legitimacy if sufficiently paralleled in discussions elsewhere, including in multilateral fora. One particularly sophisticated and potentially fruitful response offered to these concerns around representativeness is the connection developed in the book between the emergence of these standards and the international doctrine of abuse of rights. Caroline positions this doctrine as a principle prohibiting misuses of power, with state sovereignty then reconceptualised as a form of conferred power. Seen in this light, the standards flow not from particular domestic understandings of good regulatory practice, but rather from the nature and limits of state sovereignty itself. This positions international law and the global regulatory standards identified in the book as a constraint on the scope of a state's regulatory freedom according to its sovereignty. And as Locke himself has argued, in conferring regulatory powers on states, individuals in a state of nature would not consent, for example, to the arbitrary exercise of such powers, as this would put them in a position that would be worse than their condition in a state of nature. And as I have argued in my own work, such a view of state sovereignty generates implied limits on the scope of state decision-making authority, which international adjudicators articulate and enforce through their review of domestic regulatory activities. So understood in this way, the global regulatory standards identified in the book become a means for adjudicators to delimit the outer bounds of state sovereignty. Caroline's work indicates that these outer bounds require coherent decision-making, due regard for the rights of others, and due diligence in the prevention of harm. As Caroline notes in the book, these standards in practice are in fact quite accommodating of domestic regulatory authority. They impose minimal burdens and thus offer a fairly conservative approach towards the enlargement of international authority. And this ultimately ensures that the regulatory standards adopted are capable of enhancing the authority of both national and international law. The narrative presented in this book is nevertheless one of convergence. Caroline argues that with time, these global regulatory standards may become an entrenched feature of general international law. So given the weight of the practice identified in the book, the reader is left with many interesting questions on which to reflect, including how representative such standards are, whether new regulatory standards could and should be developed, and what innovations in treaty text might be required to counter the pull of the existing standards. And in raising these questions, this book serves as an excellent example of a growing body of literature that takes a more comparative and holistic view of international dispute settlement and of the contributions that international courts and tribunals can make and should be making to the development of principles to regulate the intersection between different legal orders. As you've no doubt seen from the reflections offered even just in today's launch, the book holds relevance for all those interested in the function of international law, in the role of international courts and tribunals in developing it, and in the impact of their decisions on the scope of state sovereignty and domestic regulatory freedom. So I highly commend the book and recommend it to all of you.
Thank you, Esme. So we have a rich set of reflections from our discussants. I'll now hand back over to Caroline for 10 minutes to respond to some of that. And those of you who are wishing to ask some questions, perhaps if you use the chat function to indicate questions, and I'll also be putting up some details in chat on the way in which this wonderful book can be acquired. Over to you, Caroline.
Well, thanks, Don. And I'm looking forward to people's questions, so do post those in the chat. And thank you, everybody, for these wide-ranging, thought-provoking and often challenging comments and questions. What I'm going to do is start with a few points made by Chester and work from there. Chester asks about global administrative law, standard of review, deference, proportionality, and scientific evidence. On scientific evidence, I refer you to my previous book on science and international courts and tribunals. Chester, yes, the book complements work on global administrative law by scholars such as Benedict Kingsbury and Richard Stewart and Nico Krish. in setting out, certainly global administrative law sets out principles to guide accountability and administrative decision making, both at the international and the domestic levels. And of course, all of these may well apply beyond the environmental and health context, depending on the situation. Time will tell us more, I think. However, what I would say is that the book expresses the view that adjudication of international legal regulatory disputes isn't first and foremost judicial review. It's true that the standards we're seeing serve functionally to refine allocation of decision-making power vertically between domestic and international law, but there are important ways in which this differs from judicial review. It's in principle adjudication on the merits. The rules that apply are identified by applying principles of treaty interpretation. These rules define the terms of primarily horizontal relations between and among states. Governments might prefer their representatives to use the language of judicial review and standard of review, in part because it may serve a domestic political purpose by making, say, trade and investment disputes sound more narrow and contained. However, it may not be in the interests of states and their populations, in fact, for international dispute resolution to be conceived of as judicial review. The book suggests that thinking of global regulatory standards as standards of review and calling this judicial review may distort the underlying character of the legal relations and may be problematic also in light of systemic considerations such as those relating to the place of private actors in international law, which Chester mentioned, and also the fragmentation of international law. In particular, it tends to reframe, as Chester's remarks indicated, investment treaty arbitration, and Margaret alluded to this as well, as though investors have been given substantive rights under these instruments rather than essentially procedural rights to arbitrate. Inadvertently, perhaps this could bootstrap up the status of private business entities within public international law, with implications for the maintenance of a public international legal system where formal power and status within the legal system are generally held by public actors. I find little evidence of the idea that investors have substantive rights, certainly in terms of formal authority, other than in the minds of a few arbitrators. And were the idea to take hold more widely, it could be viewed as a potential step change in the international legal order with long-term implications. The book uses the term standards in a different sense to standards of review, even though, yes, pulling back the blinds, it's talking about what we refer to as standards of review, but it's using the term standards in a different sense. There's a distinction in certain strands of legal literature between rules and standards. And any given legal provision needs to be understood as likely to incorporate both rules and standards. Standards require further subsequent articulation or elaboration, for example, by an administrative body or a court. And these elaborations are what we're seeing in the cases studied in the book. The book also takes the view that deference operates regardless of whether we talk about international adjudication in the language of judicial review and standards of review, as Esme has observed in her writing, and deference will often be built into legal rules and interpretations of international law. Finally, Chester struck, I think, a note of scepticism about reliance on proportionality testing and investment arbitration. Proportionality's promise as a means to reconcile competing international legal interests and help achieve the best substantive outcomes makes it a potentially powerful tool. But the idea that this should be introduced into investment treaty law by international adjudicatory bodies is troubling. And as Chester and Margaret have indicated, I do seek a fundamental adjustment in investment tribunals' approach, grounded in a view of investment treaties as bargains between states, and advocating for arbitrators to seriously consider reading in the due regard standard where they might otherwise have considered reading in a proportionality test. Esme raised issues including the nature of global regulatory standards, sovereignty, and abuse of rights. Esme, yes, international courts and tribunals' articulation of these global regulatory standards suggests that their observance is a matter of good practice, but at the same time, the standards are, of course, much more than this. They specify states' regulatory responsibilities, and they specify limitations on states' regulatory freedoms. The book calls them global regulatory standards because they seem to apply globally. certainly they are appearing based on empirical evidence in international adjudicatory decisions across a wide range of different areas of international law, trade, oceans, investment, watercourses law, and more. They're not static. They can be expected to evolve and change in context, fall in and out of fashion, at least at this stage in their development, and perhaps continuously. A good example of evolution is seen in WTO law, where the appellate body softened its rational relationship testing to accommodate situations where states were pursuing more than one legitimate objective at the same time. And the standards provide templates rather than answers. They're like algorithms. They make the law more specific so as to enable its consistent application, but the outcome in a given case still depends on the facts. As to whose traditions they represent, yes, there are issues here. The research for the book showed that at times the pleadings in regulatory cases can be highly influential. The idea that the regulatory coherence standard should involve proportionality testing seems like a strong example of where the research reveals a possible legal cultural bias, perhaps toward German and European-inspired ways of thinking about containment of government powers. Esme also makes an important point about sovereignty. In the elaboration of regulatory standards, international courts and tribunals do appear frequently to be drawing on a logic according to which states' powers and sovereignty itself appear inherently limited and by their nature subject to certain regulatory limits and responsibilities, an idea also seen in your own recent excellent book, Esme. And the international law abuse of rights doctrine feeds this reasoning. I won't go into that in the interest of time, but encourage you to think about how its formulation as a misuse of powers the discipline is beginning to show through in cases such as navigational rights in the ICJ. And also to comment that much of this has been foreseen. If we look back to the writings of Hirsch Lauterpacht, we can see how it was commented that the growing integration of the international community meant that we could never continue to take an absolute conception of rights. Condensing my thoughts a little in the interests of time, Margaret's 3 questions. Is there a systemic asymmetry in the non-availability of obligatory adjudication for environmental disputes? And does this lead to more leeway and perhaps a downward pressure on standards? Could this make an international court perhaps more wary of the standards that it imposes on states, or make it harder to get consensus in judicial deliberations? Due diligence might be an example of this. Obviously, international courts and tribunals have given various indications of what due diligence may entail, although the work of the ILC has also been important and that of the ILA as well. But there is a persuasive critique that due diligence sets the, as articulated by international courts and tribunals, may set the bar too low. So a best effort standard is not a standard for environmental protection that we would necessarily tolerate within national jurisdictions. But that said, due diligence and regulatory coherence and due regard are likely nevertheless to be very important in dealing with major problems, including climate change, pandemic prevention and response, the protection of biodiversity beyond national jurisdiction, and the plastics problem on which negotiations are to commence. And it may be that specifically due diligence and due regard are components of states' general duties of cooperation, as mentioned in the book. So it'll be interesting to see what might come out of any ICJ advisory opinion on climate change, as Vanuatu is currently campaigning for. And this ties in with the point that Esme raised about advisory opinions. I think probably what's important there is to say that even in advisory proceedings, though they may hold some promise in terms of broader representation, there's no guarantee that the submissions received will reflect proper deliberation within states' populations. So maybe we're needing to somehow take the lid off the box, open up democracy, so forth, if we want better representation in the production of international law. Margaret's second question I thought was truly fascinating, and the insight into how domestic regulatory agencies may be impacted in a lasting way by international litigation. And one wonders whether a future where multiple public actors from both domestic and international law are alive to the vital relevance of international law is potentially the most fruitful. And in fact, what we're really seeing is an interconnection, dialogue and exchange of views over time between all these actors, including international courts, to produce such standards. Finally, the third question for Margaret on how states can know what a due regard standard may require of them. That's a very reasonable question. We have the Chagas Islands Marine Protected Area formula, where due regard required consideration of the nature of the rights held by Mauritius, their importance, the extent of the anticipated impairment, and the nature and importance of the activities contemplated by the UK and the availability of alternative approaches. That's a pretty demanding formula, and it was of course indicated by the Tribunal that it was not setting down a universal rule when it articulated that. But what's captured there is intriguing. At its most demanding, it seems as though due regard could be some kind of procedural proportionality test like that seen in the domestic human rights law of a number of jurisdictions. But what would seem to be important would be that states act in good faith, and I would advise that if they act in good faith, they act logically, they evidence everything that they do, and they show how they have actively considered and analysed the interests of others, and also the recommendations of international organisations, for instance, International Whaling Commission advice, for example, that would help demonstrate that they had showed due regard to the interests of others. So thank you for the really fascinating questions and all of the comments. It's been absolutely great to engage, and I'm curious to see too what questions we might have from the floor.
Thank you, Caroline. And we do have a question from the floor, so I'm going to invite Eve Massingham to make that question. Eve, the floor is yours.
Oh, hi, thank you, and thanks Caroline and the discussants for the really interesting discussion. It's lovely to see some familiar faces here. I'm definitely not an expert in any of this, so please excuse me, Caroline, if my question doesn't make a lot of sense, but I was particularly interested by the discussion, and this came from Margaret's third question to you, in particular, so the timing is nice. Can we just return to that around this sort of idea of how do you practically or pragmatically meet these obligations? And I was wondering whether you think there's any sort of structural aspect to this. And I say this because I've done quite a lot of work on ensuring respect for the laws of armed conflict. And Dr. Sarah McCosker wrote a very interesting contribution to some work that I was doing, where she talks about the way in which I suppose states can structurally get their own house in order in terms of processes for engaging in humanitarian diplomacy and processes for engaging in getting things ready for their dealing with other states. And I guess when you were talking about this, I was just wondering whether you think any of those reflections around sort of having structures within one's own government which have identified these particular issues and ways for determining what is appropriate and what measures need to be taken into account, what evaluations need to be taken into account. And I just wondered if you thought maybe there were any parallels there.
Caroline, I'll hand it back to you, and then after that I'll hand it over to Margaret, Chester and Esme for some short concluding remarks before we close. So Caroline.
Thanks, Eve. Nice to see you. And what a great question. Yeah, so structurally and pragmatically, what can be done, including in other areas like in helping ensure respect for the law of armed conflict. Although, of course, in some situations, as we know at present, that's especially challenging. There is, of course, much to be said for getting processes in place and getting houses in order beforehand. And I do think that, in a sense, that's where the rubber hits the road. So states will be looking at their international obligations. They'll be thinking, okay, so what do we really need to do and what systems do we need to set up? So if they look at the Paris Agreement, they look at Article 4.2 and they think, okay, that says that when we adopt, domestic measures, they're supposed to give effect to the aims of the objectives of the Paris Agreement in terms of emissions reduction. So that looks like there's supposed to be some kind of relationship between our implementation actions and the overarching goals. And they might think, oh, that's regulatory coherence. They probably won't because they haven't probably read my book, but it is. So they would set up some kind of a structure around that, and hopefully the same with pandemic prevention and response. I'm seeking to inject some of these ideas and how they really are quite functionally important into the treaty negotiations there. And what it would be good to see is actually compliance mechanisms playing out that facilitate compliance by helping states to do some of these things, some of these setting up in advance that are less demanding than you might see in an international court or tribunal when it's after the fact and what a state's done is being pulled apart and being held to account in that way. But rather, states are going through processes of review, maybe taking the Paris Agreement non-compliance, facilitated non-compliance model, adapting that for the pandemic treaty, for example, or possibly, you know, there are hints of a possible compliance mechanism in regard to BBNJ in future, even if we don't see it coming out of the current negotiations, perhaps thinking about how it could be applied in respect of marine environmental protection. But it's, you know, like a change in the way that we parent. Perhaps there are generational changes, and maybe this is a generational change as the structure of international law develops, to think differently about compliance and accountability and help states to actually put those processes in place a bit more.
Thanks, Caroline. So now I'll just quickly move around with our discussants for some final concluding remarks. I'll just hand to Margaret, and then Chester, if you want to follow up, and then finally to Esme. So Margaret.
Well, yes, thank you, Caroline, for answering the questions that I raised and for engaging in such a detailed manner with those questions. So there's no time to continue the conversation here. We can take it offline. Just to conclude on the point that also was raised by Eve about the due regard standard, and I think it's evident from your answer as well as from global developments how that standard is going to be so integral moving forward as we realize how interconnected all of the health and environmental issues we face truly are. One doesn't want to be facetious, but one can almost see a be kind regulatory standard on the part of countries who have to consider how their activities impact on others. And this is something E.R. Benvenisti discussed quite a few years ago when he talked about the accountability of states to others and how that was developing conceptually. And I think you've given us some really great insights into how that can develop institutionally and substantively. So thank you again, Caroline.
Thank you very much, Caroline, for your response to my comment. So really appreciate your thoughtful reactions. I suppose on the no substantive rights under investment treaties point, I guess the jury's going to be out on that. And I guess I'm entirely with you on thinking that the due regard approach is a much better way to balance the rights of the parties. But I guess there's always going to be tribunals out there, the one I mentioned, plus a handful of others, plus other scholars who think that investors do have substantive rights. And of course, they'll find support in judgments of the ICJ, like Legrand, where it's confirmed that individuals can have rights conferred on them under treaties, not just procedural rights, but substantive rights as well. So I'll be interested to watch this space. And of course, I'll be barracking for the due regard standard. But I guess that there might just be a few bumps in the road ahead, I suppose, on that issue. But really love your book. It's a real tour de force, and congratulations. And thank you once again for having me along.
I guess just to chime in and maybe link up to some of Margaret's remarks, I think almost I'd encourage you to write a third book thinking about the path not travelled and the kind of where we lose creative responses to regulation through convergence and kind of thinking about Margaret's call of fragmentation leading to potentially productive frictions, and what do we lose out on in terms of regulatory tests by focusing on these three that are emerging, and how can states take different approaches if they so wish. And I guess reflecting on all of the comments tonight, how's all of that impacting domestic regulation and regulatory decisions at the domestic level. So definitely, I think a super interesting research agenda should you wish to pursue it post this book, but a really fascinating book that raises a lot of really interesting questions, and be really interesting to see how these issues are kind of raised by states and developed by international courts and tribunals going forward.
Well, there we have it, everyone. We've had a very rich discussion around Caroline's book, and Esme has just plotted the course for Caroline's next book on the subject. So, Caroline, we look forward to reconvening at some point in the future to discuss the next contribution to the field. So look, this event this evening was really designed as a celebration for Caroline, a colleague that many of us have worked with in a number of capacities, in my case, for many, many years. So Caroline, congratulations on the book. We've been delighted to hear your thoughts on some aspects of the book and to get some feedback from some of our colleagues. We wish you well for its success. I've put up some details in the chat function about how you can obtain it. And so can I just close on behalf of the Centre for International and Public Law and the ANU to thank Caroline and our three discussants this evening and wish you all a good evening. Good night.